Hey guys and gals, this is the Bar Exam and Chill podcast. I'm your host TJ. Today we have an MEE question from the UBE Bar Exam administered on February 2023. This is a civil procedure essay. Let's get right into it. Big city in State A and small town in State B are located 10 miles apart. A woman and a man were driving in State B when their cars collided with each other. The collision seriously injured the man. Shortly after the collision, the man sued the woman in the federal district court for the District of State B, properly invoking the court's diversity jurisdiction. The woman is a citizen of State A. The man is a citizen of State B. The man's complaint sought damages of $250,000 and alleged that the woman's negligent driving had caused the accident and his injuries. The woman immediately contacted her automobile insurance company to notify it about the lawsuit and to ask the company to provide an attorney to represent her in the action and to indemnify her against any liability, as required by the terms of the insurance policy. The insurance company, however, refused to provide an attorney. The insurance company told the woman that because she had not paid her premiums for several months before the accident, her policy had lapsed and therefore did not cover the accident. The woman insisted that she was current on her payments and that the policy should still be in effect. The woman then went to the clerk's office for the federal district court for the District of State B, which is located in small town. She timely filed an answer to the man's complaint. She simultaneously timely filed a complaint against the insurance company, naming it as a third-party defendant in the action pending against her in that court and alleging that the insurance company was obligated under the insurance policy to defend her in the man's suit and to indemnify her if she was found liable to the man. She also obtained from the clerk of court a summons to the insurance company requiring the company to file an answer to the woman's complaint or be subject to a default judgment. She then returned to State A, where she hired a process server. 10 days later, the process server personally delivered the summons and complaint to the president of the insurance company at the headquarters in Big City, State A. The insurance company does no business in State B and has no facilities in State B. The insurance company moved to dismiss the complaint against it. The district court granted the motion, ruling that A, the insurance company, cannot be joined to the suit as a third-party defendant because its presence is unnecessary to resolve the dispute between the man and the woman. And B, the court lacks personal jurisdiction over the insurance company because the company lacks sufficient contacts with State B. Question 1. Do the federal rules of civil procedure permit the woman to bring the company into the action as a third-party defendant? Explain. Question 2. Assuming that the federal rules of civil procedure permit the woman to bring the company into the action, does the court have personal jurisdiction over the company, despite the company's lack of contacts with State B? Explain. Question 3. Under the federal rules of civil procedure, what actions, if any, could be taken by the district court to allow the woman to immediately appeal the court's dismissal of her complaint against the insurance company? Should the court take those actions? Explain. All right, so question 1 is asking us, the issue here is, can this woman bring the insurance company into the action as a third-party defendant? This is an Impleader claim under FRCP 14. And here, the rule is basically that a third-party plaintiff can serve a summons and third-party complaint on a non-party, quote, who is or may be liable to it for all or part of the claim against it. So here, this is a pretty typical third-party complaint against a defendant. It's just a standard Impleader claim. So yes, the insurance company may be liable to the woman here, the third-party plaintiff, for all or part of the claim against it because they have a contract and she's covered under an insurance policy is her argument. Now they're saying that, they're not, it's that she lapsed on her payments and that they're not liable, but that has to be litigated. So it may be that they are liable, right? That's why they put that language in there, who is or may be liable to it for all or part of the claim against it. This rule is designed to promote judicial efficiency by allowing related claims, right? typically this is going to be indemnity or contribution. Those are the two things that the Impleader claim covers to be resolved in one action, right? Leave of court, by the way, is not required if the third-party complaint is filed within 14 days of the original answer. Here in the facts it gives us, let's see. It says the woman filed it simultaneously with her timely answer, so it was as of right. Here, the woman alleges the insurance company is obligated under her automobile policy to defend her in the man's suit and to indemnify her if found liable. That's just classic, so yes, she can bring this claim, this Impleader claim. The district court's ruling here, by the way, it says down there that as A, one of the first ruling here is A, they cannot be joined because the presence is unnecessary to resolve the dispute between the man and the woman. It seems like maybe they want you to point out that this is confusing Rule 19, which is for mandatory joinder. Impleader is permissive, right? It's allowed whenever they may be liable. So that condition's met, and yes, she can bring this claim. The court got it wrong on the law. Therefore, the FRCP here is gonna permit the Impleader. That one's really straightforward. Let's get into question 2. So assuming the federal rules permit the woman to bring the company into the action, does the court have personal jurisdiction over the company despite the company's lack of contacts with State B? Explain. Now that's really important here. In the question, they are saying the company lacks contacts. So it's a little bit unclear to me. I mean, I would honestly be a little confused if I got this on the bar exam. I would still go through probably just because I'm not even sure if I would know the exception that it's testing on actual test day. I am not sure. But you're going to have to do your best, right? So it does give you here that the company lacks contacts. Now, does that mean that you can't conduct an analysis for minimum contacts? They probably don't want you to, but you might just start off and just lay out kind of how personal jurisdiction works generally. I don't think that would, you're not going to be penalized for discussing the personal jurisdiction. But I'm just saying I don't know if you'll get points for that or not, right? It's being very specific and pointed here, despite the company's lack of contact. So I don't know if they definitely don't want a really long analysis on the minimum contacts, which is typically what they do. But let's just get into the law of personal jurisdiction and go through your rule statements here. So before looking at the Constitution, you got to check the state's own law and basically analyze the long arm statute. And a lot of times they'll give you, this is not something that probably is going to come up too terribly often in the bar exam. It's probably more of an MBE thing, because there's not really a lot of analysis to do here, right? A lot of states like California have a statute that says we have jurisdiction to the full extent of the U.S. Constitution. And if that's the case, then there's not really anything to analyze. You're just going to do the constitutional analysis for the long arm statute, right? There's not anything to analyze for the long arm statute. And then the only other really option is it may have a specific or an enumerated statute where it specifically says like what acts are allowed that grant jurisdiction. If that's the case, then you would literally just read the long arm statute and kind of figure out if there's personal jurisdiction or not. So that's why I don't think on an essay question you're ever going to really, maybe, but it's probably unlikely that you get like a long analysis on a long arm statute. But that's kind of how that works. You go through the long arm statute, you say, okay, if it's to the limits of the Constitution, then what's the constitutional analysis? Under International Shoe, which is the big law school case, a defendant must have minimum contacts. There's your keywords that you're probably going to throw up bold in a header so you can get some points. You got to have minimum contacts with the forum such that the suit does not offend, quote, traditional notions of fair play and substantial justice. That quote there you should have memorized for the bar exam. So minimum contacts that do not offend traditional notions of fair play and substantial justice. That's going to be generally broken into two categories for personal jurisdiction. You have general jurisdiction, which you'll start with maybe. You'll kind of analyze, is there general jurisdiction here or specific jurisdiction? So what's general jurisdiction? That's pretty clear. It allows a defendant to be sued in the forum for any claim, right? If the court has general jurisdiction, then they can hear basically anything against you, even if it happened in a different state or whatever. But the standard here is going to be that the defendant must be essentially at home in the forum. Well, what does that mean? If you've got an individual, like a person, this is going to be where they're domiciled. And, domiciled comes up in a lot of different areas of the law here. Domiciled is your presence and intent to remain. So you need both of those. So wherever you're domiciled, it's not only that you're there, but do you intend to remain there? For corporations, the analysis is going to be really just about two places, right? Where I think that's called the Hertz Nerve Center test if you want to cite to something. It's where they are incorporated and where they have their principal place of business, the nerve center test, yeah. Simply, if you're just like kind of doing business in the area, that's not going to be enough for general personal jurisdiction. That used to be the case, but I guess the law changed. So now we have this Hertz Nerve Center test. You've got it where it's incorporated. So if it's like a Delaware corporation, then Delaware. And where its principal place of business is, that's typically going to be like where the officers and the head honchos are at, right? And you might list that on your filings with the Secretary of State. So do we have general jurisdiction here? No, right? The insurance company has nothing to do with State B. It just gives us that, right? It's just totally located in State A. It doesn't have any facilities. It's got nothing. It's got no contacts, right? They just give us that. That's why they probably don't want a lengthy analysis, but you might just want to go through and say on the essay, okay, here's generally how personal jurisdiction works quickly. Specific jurisdiction, okay, so if you don't have general jurisdiction, you go into the specific jurisdiction. This is going to allow the defendant to be sued where the claims arise out of or relate to the specific contacts with the forum. So this is the minimum contacts analysis. For minimum contacts, you want to have 3 elements memorized, right? Your keywords here, you might throw them up in headings. In a lot of civil procedure essays, you're going to just basically go through these 3 things for minimum contacts and analyze, do they exist or not? And usually one person's going to have an argument, X, and then the other person's going to have a counter argument. Your 3 elements for minimum contacts are, you need purposeful availment, foreseeability, and relatedness. So those are your 3. If you say, hey, minimum contacts, in your head, you got to go through flashcards and say, number 1, purposeful availment. Number 2, foreseeability. Number 3, relatedness. So what is purposeful availment? The defendant must have reached out to the forum and actually, availed itself of the laws of that forum. It cannot be the result of the plaintiff's unilateral activity. That is the key thing here. Actually, I think, we read this case. I think it's called like Volkswagen or something, or something like that. But that case basically says, even for an insurance company, if they cover you for an insurance contract and you just drive into the state and have an accident, if the insurance company has no contacts with that state, surprisingly, they're not going to have constitutional specific jurisdiction over that defendant, over the insurance company. If they don't advertise there, they don't have any employees there, they don't do any business there, then the plaintiff can't, by just driving into that, subject that company to the jurisdiction of a court in that forum. That's a little bit surprising here, right? I mean, in this one, they give that to you. They just say, hey, there's no minimum contacts. So you're not going to do a whole lot of debate on that. You're just basically going to go through probably and just say, here is how personal jurisdiction works. We're given that there is no minimum contacts, so they don't have specific jurisdiction. That's it, right? You're probably not going to go into this whole purposeful availment, foreseeability, and relatedness because it just gives it to you. But I'm just going through the law so what are you, if you're in a civil procedure question in the bar and it's asking for minimum contacts, you need 3 things, right? It's got to arise out of or relate to the specific contacts of the forum, purposeful availment, foreseeability, relatedness. Those are the only 3 things you got to remember. Foreseeability, it's got to be foreseeable that the defendant could have been hailed into court, right? It's got to be foreseeable that they would have use the basic laws of that jurisdiction. And relatedness, the claim must actually result from those contacts. So is the contact related to the claim, right? If a defendant sells a defective toaster in Maine, they can't be sued in specific jurisdiction in Florida for a car accident that happened in Georgia. They've got to arise out of or relate to. You got those 3 factors. You're not going to do a lot of analysis on that here. There's the specific exemption that they're testing, and I may have been blown out on this if I got this myself without having time to research it. So, again, forcing a company with 0 physical or economic presence in State B to defend a lawsuit there is often considered a violation of those, quote-unquote, traditional notions of fair play and substantial justice. So you get your little keyword in there, get some points. Traditional notions of fair play and substantial justice. It's not going to be fair for the insurance company to have to litigate in State B if they have no contacts there. And it gives you that there's no contacts. So you just say that, right? Maybe you're kind of confused. I was also a little bit taken aback by this when I first learned about it in law school, right? you're saying, hey, but the policy covers the whole country, or it covers this. There's an insurance policy with the person that drove there. Shouldn't they be allowed, expected to be sued? Isn't that pretty foreseeable that your person that you're suing, the person that you're insuring would drive and have an accident somewhere? That seems pretty foreseeable, but some cases kind of leaned into that. But the modern court, I think it's under a case called Bristol Myers Squibb, if I remember correctly. It's basically said that there's this requirement that the defendant's own actions must connect to the forum state. That's the relatedness, right? So here you lack that. So you just basically say that and move into the correct answer, which is this exception that we're going to talk about, the 100-mile Bulge rule. So although the company doesn't do business and has no facilities in state B, so it gives us that it lacks minimum contacts with the forum state, there's this 100-mile Bulge rule. It comes out of the FRCP 4. It's an exception that you may or may not know about. So FRCP 4 has this exception that provides that for service on a third-party defendant, specifically under Rule 14, right, this Impleader claim, a federal district court may exercise personal jurisdiction over a person or entity served within 100 miles of the courthouse, even if that location is outside the state in which the district court sits, and even if the party lacks minimum contacts with the forum state. So right at the top of this, the very first sentence, right, it gives us here, and anytime they're talking about distance, you're going to want to pay special attention, and probably your eyes should perk up with that. May be very significant, right? It says here, big city, the very first sentence of this hypo, big city in state A and small town in state B are located 10 miles apart. So we have this 100-mile Bulge rule. It gives us that the courthouse is there, right? And that she serves it on the president in big city in state A. So here we've got this exception. Let's kind of talk about it a little bit. The federal district court here is in small town state B. The insurance company's headquarters is in big city state A. Gives us in that first sentence they're only 10 miles away. The woman, it says in the facts here that the woman, right, properly served the president. That's an officer, so that's going to be sufficient for service. You can serve an officer of a company, and they served him at the headquarters, which is located in big city in state A. We're given that service was timely. It says here in the facts that you've got, let's see, where does it say this? She served it 10 days after filing. So here, this Bulge rule therefore confers personal jurisdiction despite the company's lack of contacts. That's the tricky one. This exercise will also satisfy due process because the rule itself is narrowly tailored to the Impleader cases involving nearby parties, and because the underlying accident was in state B, that further supports like reasonableness, right? Because it seems like this is all kind of related. Therefore, you're going to say, hey, look, this district court's ruling was not correct. In the hypo here, it says the court basically did two things, right, which we already resolved. The first one, where they said, hey, they kind of mixed up that Rule 19 for mandatory joinder. They said, hey, it cannot be joined because the third-party defendant is unnecessary to resolve the dispute. That's for mandatory. But here we've got an Impleader claim, so that's not the standard. It's actually permissive, and it's just basically a straightforward Rule 14 third-party defendant, so it's going to be okay, right? And then it says, what else did the court do? B, the court lacks personal jurisdiction over the insurance company because the company lacks sufficient contacts with state B. And we take that at their word, and they give it to us directly in the question. But yeah, they don't have any facilities there. It says that in the facts. They got nothing there. So unless you would have had this Bulge exception, your SOL, the insurance company, probably may have gotten away with it, just as the court said. But here we've got this exception to worry about. So that should take care of that one. Let's go into question number 3. This is asking us, under the rules of federal rules of civil procedure, what actions, if any, could be taken by the district court to allow the woman to immediately appeal the court's dismissal of her complaint against the insurance company? And should the court take that action? This is going to be testing us on the final judgment rule. This is found in FRCP 54. If you want to appeal, basically you've got interlocutory appeals, which can be done only in very specific instances. So let's talk a little bit about when you can do an interlocutory appeal. That's just saying that you appeal before there's an actual final judgment. They're really strict about this in practice, by the way. You'll have to do research on this probably if you litigate for long enough. So under the collateral order doctrine, you would be able to immediately appeal a decision that's not a final judgment. There's a 3-part test there. When can you do that? Well, you've got 1, 2, 3. Rule number 1, it's got to be conclusive. The order has to conclusively determine the disputed question. Number 2, it's got to be separate. The issue has to be completely separate from the merits of the main action. Number 3, it's got to be unreviewable. The decision is effectively unreviewable on appeal from final judgment. So this is going to be why the collateral order doctrine is not going to work here, right? The decision dismissing that insurance company would be appealable from an order of final judgment. So this whole thing just doesn't apply, and it's not an unreviewable order. If the woman is going to be forced to litigate against the insurance company, the woman is going to be forced to litigate against this man. The court has just dismissed this insurance company. They got rid of them. Well, that doesn't kill the case, right? This case is ongoing. She's going to have to litigate against the guy for the accident. He's still going to proceed in court saying, hey, you wrecked into me and it's all your fault. You know, that's why here there's not going to be a final judgment. They didn't just dismiss the whole case. They only got rid of the insurance company, who was the third party defendant here. So that's not going to apply. And then in the U.S. Code and in the federal rules, basically, you've got these other like enumerated times when you can file an interlocutory appeal, but they're really specific instances. So let's kind of go through when would that be? In a denial of qualified immunity. These may come up on the MBE. I'm not, I have seen these questions on there. They're pretty hard. Interlocutory appeal is a subject matter, is something that you want to be aware of. I'm not sure if it's the most high yield rule, but it's something to be aware of. So when can you file these interlocutory appeals? On a denial of qualified immunity, if they deny government official immunity to stay in trial. Orders affecting injunctions. So if there's an order granting, continuing, modifying, refusing, or dissolving injunctions, you're going to be able to file an interlocutory appeal. That's probably the most common thing that you might see and you'd want to be aware of, because they do test injunctions on the bar exam. So if you have an order that's like granting or denying an injunction, because it's such a serious thing, they're going to allow you to immediately appeal it, even if there's not a final judgment. And also, you can seek certification by district court. In your practice, this is going to be the most common thing, right? If you have this horrible ruling by a judge that is kind of going to screw up or fuck up your whole case, and it's going to proceed anyway, right? There's no final judgment. They just like eliminated your case on some critical thing that doesn't actually get rid of the whole case on the merits. Then you would actually seek certification by the district court. You would basically apply for the federal judge and say, hey, look, we want you to certify that there's an order, to give us an order, and there's a standard by which they would seek certification. It has to involve a controlling question of law where immediate appeal may advance termination of the litigation. They really are worried about this kind of stuff policy-wise in the court system. The dockets are so backed up and everything that you want to try and like appeal to the judge and say, look, if you give us this, it's going to terminate this litigation. It's going to get it off your docket. So that's how you try and seek certification in the district court. This is pretty common to do if you're in federal court. And then the other one that you want to be aware of is receiverships. Orders appointing or refusing to appoint receivers are immediately appealable. There's an interlocutory appeal that you can file even if there's no final judgment. So you went through all those. None of that shit applies here. You don't have, right? There's no collateral order doctrine because the decision is not unreviewable. It is reviewable. If the case went all the way and it was litigated through trial and the guy won and they found that this woman was liable to him, then they could appeal from that and they could review that order dismissing the insurance company. That's why. I mean, it's a little bit complicated there, but that's how it would work procedurally. So we don't have any of this stuff to file an interlocutory appeal. That's the whole point, right? And this question, the issue here in question 3, is what actions should the court take to allow her to immediately appeal the court's dismissal? Well, there cannot be an interlocutory appeal, so none of that applies. You might want to go through some of that stuff if you're aware of it and just say, hey, she's not going to be able to get, any of these things. The collateral order doctrine doesn't apply quickly, and she can't get probably certification by the district court. because it's not really a controlling question of law where immediate appeal may advance termination of the litigation, right? It's only as to this third-party insurance company. So it's not going to lead to a termination of the litigation. It's just going to it's going to be ongoing, right? This docket's going to be filled up, and if the insurance company's brought in, you continue litigating. If they're not, you still continue litigating against the guy. That's why there's this certification by the district court is not going to work either. So the question here is there anything the court can do to allow this to be immediately appealable? Now, this is also a little bit of an obscure rule here. It's in FRCP 54. It's 54B. Under 54B, the district court can direct entry of final judgment itself, which would make the dismissal immediately appealable. So it can say, hey, look, this is a final judgment for purposes of allowing you to appeal. So the general final judgment rule, that's going to be under the U.S. Code. It permits appeals, the definition there, it permits appeals only from final decisions that end the litigation on the merits. That's not going on here, just as we discussed. Here, the dismissal of the third-party complaint leaves the main action. It's the guy. They're going to continue litigating. So FRCP 54B, it creates an exception for cases like this involving multiple claims or parties. Here's the rule. When an action presents more than one claim for relief, or when multiple parties are involved, the court may direct entry of a final judgment as to one or more, but fewer than all, claims or parties only if the court expressly determines that there is no just reason for delay. Here, let's apply it to what we got going on here. This is actually a fairly typical thing that happens, right? You're going to be involved in accidents. Those are pretty common, and the insurance company is going to get involved. These are all actually pretty common things that happen. Now here, the third-party complaint is a separate claim against a separate party, right? It's the insurance company. She's trying to plead it against them and say, hey, you need to indemnify me and give me a lawyer. That has pretty much, it does have something to do with her accident with the guy that she's actually litigating at to see, am I at fault? Did I fuck up? Did I cause the accident, right? If she's liable to the guy that she wrecked into, then she's going to argue, hey, the insurance company has to indemnify me. I've got an insurance policy with them. But as we discussed, they've got no minimum contacts and so on. So here, the court dismissed that insurance company. They got rid of them. They were mistaken as we analyzed up above. And they said, okay, you don't have minimum contacts, so you're out of here. And they didn't consider that exception of the 100-mile bulge rule. The court, just like me, probably was not super aware of that. So here under FRCP 54B, the court can enter a partial final judgment here and make the express, quote, no just reason for delay finding, which it makes sense here, right? The insurance company has a policy that covers this woman. That's what she's arguing. That is pretty critical to the litigation. It's going to get litigated eventually, even if she was found liable to the guy in this district court in state B, she's probably going to go into state A and say, hey, look, it's not me that's liable. This insurance company has to pay. I have a contract with them. And if they don't cover me, then they're in breach of contract. So let's connect my liability with the insurance company. It's going to get litigated. This is a whole mess, right? So therefore, here, it makes sense for the court to say, look, let's make this dismissal of the insurance company. Let's just make it a final judgment. Under this Rule 54B, let's give it so it's immediately appealable because this seems like a pretty critical issue for the case, right? The factors the court is going to weigh here on this 54B is going to include, one, whether the claims are separable, right? Tort negligence versus insurance contract and indemnity. Those are two different things. So, yes, they are separable. They're also going to consider, two, risk of inconsistent judgments if the main case proceeds first. And three, hardship or injustice from delay. The woman would face potential duplicative litigation and uncertainty, right? She's saying, hey, they have to pay for my lawyer. And so if they get dismissed, then she's going to have to litigate without that. And it seems like she's going to go through some hardship without a lawyer, right? If she's poor, she's going to have to get like a crappy whatever she can. Either a cheap lawyer or just litigate herself. That is really bad. You don't want to be a pro per or a pro se litigator. You just don't know what you're doing, right? A lot of this stuff is very complicated. How is somebody like this woman that just got in a car accident going to understand the nuances of an interlocutory appeal? It's a little difficult. So is she going to face hardship? Yes, she needs that insurance company. She's saying, hey, they have to pay for my lawyer and indemnify me. So all of these are going to be met, and an immediate resolution here of the coverage issue is going to materially advance the litigation to avoid waste. So here you've got this exception. It falls neatly within this category of FRCP 54B, which says, hey, look, if there's multiple claims or multiple parties, when an action presents more than one claim for relief, or when multiple parties are involved, the court can direct entry of final judgment as to one or more, but fewer than all claims or parties, only if the court expressly determines that there is no just reason for delay. So is there a just reason? Is there no just reason for delay? Yeah, I mean, they want this. They want to certify this basically for appeal so that she can figure out whether the insurance company has to litigate for her in this forum and maybe indemnify her ultimately if she's found liable. Here it seems like the court should take this action. The claims are legally and factually distinct, right? Just like we said, the third party, it's insurance contract versus this tort liability. The third party issue is collateral in the practical sense. And if you delay the appeal until final judgment, it's going to force her to litigate on her own or get a lawyer, and she's going to be, significantly financially hardship by that. Just so you know, under FRCP 54B, certification is discretionary. So the court can decide. And we're saying, should the court do this? Yeah, I mean, it seems like this is pretty sensible for the court to do so that she can appeal and get an answer to this so she doesn't have to litigate on her own. So that was a toughie. I feel like that was a toughie. I don't know. If I got that one on the bar exam, interlocutory appeals and also this 100-mile bulge exception. Holy cow. But now you're aware, you've gone through, that was a pretty hard one. This kind of stuff can crop up on the MBE. You've got some more rules under your belt. And we went through the minimum contact stuff. You're typically just going to get a straightforward personal jurisdiction question. I got a straightforward minimum contacts personal jurisdiction when I took the bar exam in California, and it was not so crazy as this one. But this is good. You've got some pretty crazy rules under your belt here, and we also went through the common stuff. Impleader defendant is the impleader claims under Rule 14 are heavily tested in the MBE, as well as they come up on the essay section. So knowing about that is super helpful. And that's all we got for today. Good job. I'll see you next time.